Clip from earlier this week in the closing arguments of the Thomas Valerio case out of Nevada. We're joined now live here on the LawNewz Network with two of the attorneys who defended the man who was on death row but who now is not. Thomas Pitaro and Dustin Marcello are criminal defense attorneys in Nevada. Mr. Pitaro, it's good to see you here on the LawNewz Network.
Thank you. My pleasure.
So we listened to just a clip of your closing arguments in that case, and I just want to start out. What was your reaction to the verdict?
Well, I mean, when you started with the death case and it's not a death case, then obviously you're happy on that. As with these cases, this is not the end of the case because we think there were some structural errors leading up even to this hearing. So that'll be the issues of appeal. But at this stage, given that, death is off the table.
Yeah, so ultimately, I think this is a win for the defense. I mean, I know that it didn't result in the lesser sentence that you had ultimately argued and hoped for, I'm sure, which was the possibility of parole. I talked to the prosecutor yesterday, and according to the prosecutor, at least one of the prosecutors, the jury never considered that lesser of the three charges. Is that a bit disappointing?
No, because you have to understand the issue of group dynamics, and if the group dynamics where you go from one and you're at the other, then basically that's where it is. Where you start getting into these, if there's people on this side or that side, and things changed. I don't. Obviously, it was disappointing for her because I wanted John to at least have that opportunity. But the option that the prosecutors were looking forward to execute it.
Well, let's talk about the convoluted history of this case. You've got a case involving a 31-year-old crime. You have a defendant who sat on death row for, I think, 29 years because the original conviction was about 2 years after the crime. Okay, so then it goes up on appeal, and part of me just is frustrated over the trajectory of the case because Nevada left this depravity of mind definition in its jury instructions for apparently 15 years after the U.S. Supreme Court said it was a bad instruction. Why did it take the state so long to clean up its act?
I have absolutely no idea, because that's one of the things that we had actually, not only me, but the attorneys before me, we argued all the way through. And I think that's going to be one of the issues that will go up again of resurrecting the depravity of mind. You have to understand, for 20 years, we have not had depravity of mind in the statute. They had to go back and take a statute that no longer has it and hasn't had it for decades and resurrect it in there. And then, as you know from the case, since 2002, they spent 15 years more trying to get it on, which I think says something about the death penalty itself.
I mean, society has changed a lot since this original crime. Did you suspect in the back of your mind that maybe jurors these days are reserving the death penalty only for the absolute worst of the worst of the worst of the worst? I mean, did you think that this might come out this way?
Yes, because, I mean, that's the function of the death penalty if you believe in it, and it is for the worst of the worst. And when you throw in the 30 years that he's been in prison, it's hard to say we'll disregard that and then go back and look only at the original offense.
Wanted to ask you a little bit about your closing argument. You used a couple of analogies. You said that the defendant was sort of like Ebenezer Scrooge and sort of like the guy who wrote the song Amazing Grace, and that both had done things that were not reputable and who then reformed their ways. I thought it was an interesting analogy. Is it one that you've used before, and how did you come up with the idea for it?
Well, with the Ebenezer with Scrooge, I was saying that's sort of a fictional way that you can have a transformation or a reformation. The Amazing Grace was one that was roaming around in my head. I've read the book about William Wilberforce, who was the abolitionist, and John Newton was involved with him in England back then, and it was an interesting story of someone who you could put it in terms that people could understand, a slave trader, slave captain, to changing, and that's what we're trying to do, was to show that people could change. And because that to me was the fundamental issue in this case. Could they believe a person could change? If you didn't believe that, as I said, the state didn't, then you're looking at a lethal sentence. If you do believe it, then you go back and say, how do I want to handle it?
Prosecutor DiGiacomo told me yesterday that members of the jury were actually a little bit bothered by one of the lines in the defendant's allocution where he got up there and spoke to the jury. I wanted to ask you a little bit about that. How was that decision made for him to go up there and speak for about 6 minutes and 50 seconds to the jury on his own?
Well, in a death case, there's two things you can do. You can do it as an unsworn statement, where the person makes a statement like John did, or you can make a fuller statement and then subject to cross-examination. Normally what happens in that sworn statement type of situation, a person is up there trying to explain the underlying offense. Here, that was a given, has been a given for 3 decades. So going up and saying anything about that would detract from what we were trying to do.
Apparently, at least this is the prosecutor's version of it, the jurors were a little bothered that he said that he thought of the victim every day, but didn't, in the same breath at least, say that he felt sorry for the victim. And the prosecutor told me yesterday that in his version of having discussions with the jury, that they took that as maybe he had some kind of weird predilection or something. I'm not quite sure what they would have been reading into it, because I took it as being rather sincere. But did you get any such feedback from the jury? And if you hadn't, do you think the jurors were really just looking for something that wasn't there?
Well, one, I didn't talk to the jury afterwards, believe it or not. As late as I had to go down and teach at the law school, so I had to go down and teach. But I think that everyone looks at things different. Remember, John Valero has been in the prison for 30-odd years. He's not used to talking. It's probably the first time he's ever spoke to anyone in public or a public forum. So you would not expect him to be as smooth. But I took it as a sincere exposition of remorse on his part. But I think you can, if someone wants to justify that's why I did this, I didn't really do that.
Now, I wanted to ask a little bit also about the mitigating evidence here, because I was following along with at least the current statutes in Nevada about what can be presented as mitigating evidence. But ultimately, this presented a really unique opportunity, because someone who's been on death row for 29 years was ultimately able to present to a jury mitigating evidence that came from the period during which he was incarcerated. Not everybody on death row gets to retry the case and just say, well, I'm reformed now that I've been behind bars. He was able to present the minister who he's befriended from behind bars and whatnot. So can you speak a little bit to the uniqueness of the situation?
Well, I think what you hit right upon it. It points out that most of the time when the death penalty is in fact imposed under under the normal situation, you don't have anything to look at. You're just looking right at the present, and you are now projecting the future. Here you had the future. Here you had the man as he is now, not the man as he was there, and that gets thrown into the equation. And I would dare say that in most cases where a death penalty was in fact imposed, and 30 years later you had someone similar to John who has done the things that he has done and not get into any serious trouble in there, you probably would have a similar sort of result. And so that there is the thing that those of us who oppose the death penalty are always concerned about, because once it's imposed, it's final, it's over. There is no chance to rehabilitate or redeem.
Yeah, so in other words, what I'm hearing from you is a sense that the prison system is not necessarily designed to punish, it's also designed to reform. And what I'm hearing is that in this case, you think that it resulted in a reform.
Yes, exactly. And that is one of the functions. As a matter of fact, as we know, the original penal system was in there to rehabilitate. And it was for a number of years as we went through. Then, of course, we hit the roadblock in America, which we called the war on drugs. And then we saw very, very punitive laws put in, sentences in. That's why the prison population of the United States has skyrocketed over the last couple decades, and so sometimes we forget it until you get into what is really there. I mean, probably the most telling, there was a potential juror who put that she believed in the death penalty. She felt if you were convicted of first-degree murder, that it must be imposed. There was no exception. And then when she was questioned during the voir dire, she basically said, "I've changed my mind." After having to look at a person. And that's the thing, the abstract and the real is what this case was about.
I wanted to talk a little bit about some of the objections to hearsay. As I recognize and talked about quite a bit here on LawNewz when you were in the case, you've got a trial that's 31 years after the fact here, and many witnesses are unavailable. Many were dead, many were in poor health. So we had situations of testimony being read back into the record. We had other witnesses that were testifying about playing, at the time in their career, they were playing just a minimal investigatory role in this case, but then they were testifying about broad areas of evidence recovery and whatnot. And I realized that the formal rules of evidence, the formal hearsay rules under Nevada statutes don't apply to these penalty hearings, but you were still registering objections there. Can you talk about that a little bit?
Well, where the objection, one, it still has been unsettled by the Supreme Court whether the Crawford decision applies to penalty hearings. So the objection initially there is preserving that record so it can be reviewed at some point in time. So that's the first thing. The second thing, though, is that the evidentiary rules are almost in a three penalties or a three-part phase. One, you have the guilt phase. In this case, that was gone. Then you have what's known as the aggravation stage, where the jury has to find beyond a reasonable doubt aggravators, and they have to use non-hearsay evidence. And then in the penalty, you are allowed to use hearsay. We had filed a motion to bifurcate this hearing in one where they had to use legal evidence to show the aggravators, and then that you could get into the hearsay. But the basis of that all goes back to the concept, well, when a judge sentences you, he should be able to have all the evidence that is out there. Because, you know, there's been a lot of things that have happened since then. You had the Supreme Court case in Apprendi, which put the jury back into things. You have Crawford, which is out there as hearsay, non-hearsay. So it's not as settled as it appeared to be, and that's why we were objecting at the time and filed motions concerning it.
Do you think that the testimony of the minister who had befriended your client from when he was behind bars and when she was active in the ministry all the way up in Massachusetts, do you think that her testimony was really helpful?
Yes. I think it was helpful by virtue of the fact that you had a total outsider who said, I've dealt with this person only in terms of a prison environment, only in terms as a prisoner under those circumstances, and I find the person had redeeming qualities. So, I mean, I think by having her testify, it showed her character, but it also was able to get out the character of John Valerio over the period of time. So, yeah, I think it's important. If it wasn't there, it probably would have been more important. That is, you didn't have anyone like her who would come in and do it. Remember, she did this on her own. We didn't know about her during the course of the trial. This is not during the course. I mean, the course of the history of this case. This is something that she did.
Yeah, and One thing did irk me a little bit about her testimony, and when she was asked on cross-examination if her denomination didn't believe in the death penalty, she sort of whiffed on the answer a little bit. I mean, a simple Google search can tell you that the UCC is adamantly against the death penalty, and I thought that might hurt her a little bit, but the prosecution chose not to jump into it.
Well, basically what it is, I mean, I'm a Catholic, so I'm not a Congregationalist. The Congregationalists, of course, I'm from New England, you know, they were the original Puritans, so there's a long history. But within that denomination, I think she was saying that although the church itself has a policy position against it, people can make individual choices. That's what I understood her to be saying, but that was probably more so because you know, I know a little history of that church coming from the New England area.
I did not realize that you were from New England. I spent 5 years of my life and counting there. So, you know, just wanted to sort of wrap up with a couple of broader questions here. What are your client's thoughts at this point? Is there anything you can share with us from his perspective about how this retrial happened, maybe even how the original case happened, and his reaction to the verdict?
Well, I mean, I can't go into obviously anything that has been said between us or Mr. Erickson, but I think what this case has and will show that the person that was in court is going to be the person who will continue on, and that is that ultimately, as trite as it sounds, I think we all believe in the ultimate ability of people to redeem and reform themselves.
Mr. Marcello, I know that you worked on this case a little bit. How were you involved? Because I know we didn't see you there at the attorney table when we were listening to arguments.
Right. We did a lot of the pretrial work with regards to the depravity of mind, aggravating instruction, the constitutionality of that, the Ninth Circuit case law that dealt with that. And as you noted during your original question, one of the frustrating things is that you've had multiple decisions, subsequent decisions, all by the Ninth Circuit saying this thing is unconstitutional, and the constant attempt to resurrect it as the aggravator, even though in the face of constant case law, under the guise of, well, Nevada Supreme Court hasn't said it unconstitutional. So even though the Supreme Court, the Ninth Circuit, multiple times have said it, Nevada Supreme Court hasn't, so therefore we get to use it. Additionally, with the hearsay issues, the confrontation issues, we dealt extensively with that and then and got it in line. As well as the prep for the witnesses. One specific issue was with the coroner's or the ME's report, or, you know, testimony being read in, where you had science, things that she was testifying to, and that science was no longer good science. And now you can't cross-examine them about that because it's been 20 years later. Science has shown that certain conclusions she made were incorrect. Because they were based off of science back 20 years ago that's been shown to not exist or not be correct anymore.
Can you give me a specific example of something that these days would be ripped to shreds that did leak into this case?
Correct. So one thing had to do with the alcohol consumption and extrapolation of a blood alcohol level. It's been since shown that you need very specific factors to do that. You can't just, you know, guess at these things. You need very specific factors. She had made certain conclusions about that that have since that time 20 years later they've said no, you can't, it's not medically, you can't come to a medical conclusion on this without certain factors that she didn't have back then. So that's just an example. Additionally, with regards to injuries, certain types of injuries that she had testified to back then that likely would not have been confirmed now. We actually had an expert testify as to that. On those issues, but we weren't able to cross-examine her on her conclusions, obviously, because they were 20 years prior. So.
Yeah, I mean, just the procedural hoops, the nitty-gritty work in the law books, or Westlaw or LexisNexis these days, as the case may be. But going back as far as you did, maybe I had to dip into the books. I recognize, as an attorney myself, that this case required an extreme amount of unique preparation.
Yes, that's without a doubt. And you know, it was interesting. We actually had this case we had one judge for it for nearly 2.5 years for the entire case history, and then the courts switched how they designate the cases to specific judges, and suddenly we had a judge for the last month and a half that was totally different, that had not made any of the prior rulings and then made specific rulings. So this was a very unique and difficult case right from the get-go, and in trying to keep consistency and deal with these issues over so many years, so many different courts, so many different decisions on the law, so many changes in the facts, the circumstances, the evidence, and then try to get that all together in a unified format and pretend like it was 20 years ago, even though it's today, and present it to a jury. It was very difficult.
A couple of questions that I ask almost everyone I have here on Law News. I'll start with you, Attorney Pitaro. Why did you become an attorney?
Why?
Yes.
From the time I was a little boy, I wanted to be in court trying cases. It's as simple as that. As far back as I can remember, I always wanted to be attorney. No one in my family was. No one had ever gone to college, any of those things, but that's what I wanted.
And why criminal defense work specifically?
For my first year, I worked for a civil attorney, and it just bored me to death. And I like going in, and I like representing the underdog. As foolish as that sounds, most criminal defense attorneys go in there, you make a choice. Do you want to try to put people in cages? Then you become a prosecutor. If you want to take people out of cages and help in that respect, and then you become a criminal defense attorney.
What do you like about it the most?
I like the idea that you get to go up there and argue and talk about things that are relevant to our society and try to challenge the society to change. Law is a conservative profession. It's not one that, as you know, if you're an attorney, is always behind the times, I think, and we get to argue those things, and we get to try to move the society forward.
Now, Attorney Marcello, you know what questions I'm going to ask you. You're a witness who just heard the previous examination. Why criminal defense work for you?
Well, same thing. Right out of law school, neither of my parents went to college, and right out of law school, I worked at a civil firm, and they have a phrase that I remember is that civil is criminal and criminal is civil. And it has shown to be 100% true that working in the civil arena, you'd be surprised how often decisions you make negatively affect a large group of people rather than the individualized nature of criminal defense, where you represent one person against the government, against the state, and get to stand up for them. And growing up, just to answer your question, since I do know it's next, was, there was just something inherent in me that when something was unfair or not right, or I felt that it was my obligation to stand up and do something and say something about it, even if it was extremely unpopular. And Tom's absolutely right. One of the best parts of the job, I enjoyed the show. I enjoyed being in front of people, doing the thing, explaining it, and really getting one opportunity to hopefully change their mind and reflect on themselves and the history and society, and realize that, we may think we're so different, but we've basically been the same for thousands of years. And really what we're asking for most of the time is for things to be fair and equal. And, it's not just get the guy off or get a better deal. It's about what's fair and right. And that, although our attitudes about certain things have changed, our who we are as people and human beings really hasn't. So
I think the summary is that the technology changes, but what satisfies the soul does not change.
I think that's a very good way of putting it. In many respects, we're no different than we were thousands of years ago, and our decision-making process, we're now finding out, is much more basic than we ever thought it was.
We're going to wrap up here. Thomas Pitaro and Dustin Marcello, criminal defense attorneys who worked on the case of John Valerio. We watched you in court, Attorney Pitaro. We watched the results of your hard work behind the scenes, Attorney Marcello. So we appreciate you very much joining us on the Law News Network.